Okay, we are now recording. The time is 4:32.
I'd just like to state that this is the meeting of the Compliance and Amendments Committee for September 22nd.
Great, thank you. Cheryl, if you could please read
the remote access. Do remote access?
Yes, thank you.
On the Compliance and Amendments Committee for today, I'm addressing remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London and Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via video conference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process.
Thank you. I'll read the statement on meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. If you could call the first item, please.
Item number 1, call to order, roll call, and agenda changes. Roll call. Member Wolf.
Here.
Member Wolf present. Member Highland. Chris.
Present.
Member Highland present. Cheryl LaHood.
Present.
Cheryl LaHood present. We have a quorum. Are there any agenda changes?
Not as far as I know. Does anyone have any agenda changes?
Okay. I'm not hearing any changes. Anybody have anything to say?
I'll move to approve the minutes.
We're not at the minutes yet.
Oh, I'm sorry.
The agenda.
This is agenda changes right now, Bruce.
No adjustments for the agenda.
All right. So I will mark in the minutes no agenda changes. Shall I read item 2?
Yes, please.
Item 2, approval of the August 25, 2020 Compliance and Amendments Committee meeting minutes. I have a copy of the minutes. If anybody has any changes or corrections, I'm happy to note them and update the minutes as so requested.
I thought it was a very thorough summary.
Okay, thank you.
Mm-hmm. Yeah, Chris, did you have something that you wanted to address in the minutes?
We can't hear you. You're on mute.
Chris. Chris, you're on mute.
You're on mute.
Chris? Now I can't see him.
No, I have no changes on the minutes.
Oh, good. Now we can hear you. Great.
Okay.
My issue was something else. I'll get to it when we get to the item.
Oh, okay.
Okay. So,
I moved the minutes.
Do we have to do public comment?
Yeah, but we have to have a motion on the floor first.
Yeah.
All right.
So we have Bruce made a motion to approve.
Who wants to second?
Second?
Any public comment on the minutes? Seeing no public comment, I think we can take them by acclamation. And then I think we're ready for the next item.
Okay, just a second. Over here. Okay. Item number 3, public comment. Members of the public may address a committee on matters that are within the committee's jurisdiction but not on today's agenda.
Do we have anyone interested in making public comment?
All these people lined up, they don't want to say anything?
I think they're waiting to talk later.
Move it along. We got a lot to do.
Let's take the public comment is closed. Let's take the next item.
Hang on a second. Item number 4, file number 19114, complaint filed by Shane Anderes against Tyler View and the Public Defender's Office for violating Administrative Code Section 6724, 25, 26, 27, and 29 by failing to respond to an immediate disclosure request in a timely and/or complete manner. Lila, you may want to give an update on the August 25th Compliance and Amendments Committee meeting.
Yes, so we have had a lot of conversations about this this complaint. We've heard from both sides. We have the sticking point for us is that the Public Defender's Office says that the documents that are being requested are not public records because of attorney-client privilege and because these documents were gathered in the process of defending current and future clients. The committee has had some conversations about this. We had a conversation with Jeffrey Pierce at the Ethics Commission. And Bruce, should I go into some detail about that, or?
Sure.
So
if whatever's relevant.
Yeah. So we talked to him about the possibility of referring this to ethics for, in-camera review or some confidential review of the documents to help us determine whether they were public records. He did not. We talked about several different scenarios. He didn't seem to think that. Although we could pursue that course of action, there's nothing stopping us from referring to ethics that we were unlikely to be able to do what we were trying to do by following that path. Bruce had made some other possible suggestions, and Bruce, I would give you, if you'd like to explain those, you're welcome to. Jeffrey Pierce recommended that we go back to Mark Price-Wolf, who is our city attorney, and talk to him about our options and, whether we might ask the respondent for some sort of closed session meeting with him present that would allow us to have a private review of the documents. Mark suggested that would not even be allowed in a court of law, because courts are not allowed to review if one side claims that the documents are protected by attorney-client privilege. They must explain why those documents are covered by attorney-client privilege, and the other side can then argue why they are not. But the court has to make a decision based on the arguments, not on its ability to review the documents themselves. So in that sense, he thinks we need to make a decision in the same way. He also, in his opinion, we can always ask for more information about more details about how the information was collected and why, if we don't feel as though we have enough information about why it is protected by attorney-client privilege and whether it does fall under that. But again, he reiterated what we've heard from the Public Defender's Office, which is that materials gathered in the defense of current and future clients is protected by attorney-client privilege. He also thinks that Coronado does apply in this case. And that was the advice that I got from him just prior to this meeting. He said that he also could be available if we had additional questions. Bruce.
So it's a little troubling to me about it's protected by attorney-client privilege per se. It's what is protected by attorney-client privilege? The public defender not releasing the documents, or that the documents are part of attorney-client privilege? I mean, the privilege goes to the client. So are we talking about the public defender being the client, or are we talking about the public defender's clients with regards to the documents? So that then I'm a little confused by his response, legal counsel's response on that.
I think he was referring to protecting the public defender's clients, not the public defender as a client.
Okay. I just want also for everybody's edification, Jeffrey Pierce runs the investigative unit for the Ethics Commission, and they do investigations in confidentially and in secret, and then produce their findings to the commission when the item comes up. We have talked with them several times over the years about finding a way to do in-camera reviews, because they do such things in private, and where we do everything in public. So we do all our investigations right here, right here in committee. So as best as we can. So that's why, as far as DCA Wolf's response, that's why I was, I'm a little kind of confused about, which parts are applicable to Coronado, and because I find it still compelling that the documents that are being asked for is not necessarily in the same rubric as what Coronado was stating. Here, I'm just going by all the testimony and all the documentation that has been provided to us in the past two meetings now. That the requester is not asking for access to a database. He's asking for records that maybe he doesn't know is in a database or not. Coronado was specifically focused on access to a database. Now, the question then becomes does that mean that any record that's in the database, if that was pulled out and made available to the public, is that now not part and parcel to the Coronado decision, or pertinent to Coronado at all? But if we are still interested in determining whether the records are public or not, and choose to continue to go down this road, for just in the interest of the public, and making sure that there's a definitive answer, at least from us. I mean, it could always be appealed, and it could be reconsidered here by the task force if the task force decides to take a position one way or another, or it could be taken through the judicial system at that point. But if we are interested in camera review, the two areas I was thinking about, one was possibly the civil grand jury, exploring civil grand jury, because they do all their work in private, behind closed doors, and they certainly could possibly be given authority to do that. And they are similar to us, have the public's, best interest, what weighs in kind of the favor of the public kind of thing, or to find a judge and see if a judge might be interested in intervening with us just for the purposes of in-camera review. Obviously, if this goes to court, that judge would possibly have to recuse themselves, but that's not it's of no consequence to us what our needs are. So those were two things I was thinking about.
Bruce, to be clear, and my understanding, although I did not ask Mark Price-Wolf specifically, I did not ask him, would it be different if these were files in a file cabinet versus items in a database? But my understanding from what he said is that any information gathered in the course of defending current or future clients can be protected by attorney-client privilege. And it doesn't matter if the pieces themselves are otherwise, public information or public documents.
Well, but you see, the thrust of the public defender's defense is Coronado and the protection of the database that would be used, as part of strategic planning for cases, present or future. So it's not necessarily. I'm based upon my review. The thrust wasn't so much around attorney-client privilege, but more the protection of the attorney's ability to strategize a case, and the information that is being asked for is being held in confidence because it could be used as part of a case that might come or not. It's not clear to me. It wasn't clear to me. You know what I mean?
Well, the only reason an attorney is strategizing a case in the public defender's office is to defend a client.
I understand that, but the point is if the information is not currently being used in a case, then there's no client. It's just like part of their library of, kind of quote unquote protected or privileged information, like intellectual property that, is not to be made public, so is not to reveal your hand. But Jeffrey Pierce said it. Another interesting thing is that in any case, there could be any number of public available pieces of information or records that are part of a case. It could be a newspaper clipping, it could be a public document, piece of legislation, it could be any number of public records. But it is the shield and the veil of the attorney-client privilege when they have an actual client. Now, if they don't have an actual client and these specific documents are not being used in a particular case, then there's a question of it being, is it now protected by attorney-client privilege? No. It's the argument that the respondent is bringing forward is that this is like intellectual property. This is like information and intelligence that they would use as part of when they do get a client to use it as tools for strategizing and putting together a case as part of their strategy. And it's the whole purpose of the adversarial system is, not to reveal your hand, as to what your strategy is. So I get that part. But here we're, we don't know of all the records that are being asked for, how many of them are being used in actual live cases or not, or they're just being in some file cabinet waiting to be used. the question is that we don't know if they're in a file cabinet or in a database, and Coronado specifically was talking about a database.
Okay, forgive me, and maybe, but let's talk through this for a second. So let's say I am a client and information is gathered during the course of my case, and my case comes to its conclusion. Am I not under the ongoing assumption that information gathered during the course of my case will continue to remain privileged, that the attorney-client privilege that was established with me extends beyond the legal resolution of that particular case? Because what if something comes up with me again?
Maybe, because we've dealt with this with regards to police investigations, where the ongoing investigations are protected by the evidence code, police code, or what have you, any number of outside of the CPRA or within the CPRA. And what ends up happening is that no information can be released until the case is closed, okay? Goes to court or what have you, then all or some of the information can be released. The documents can be released, but they may be redacted in the same way like an FBI file. Yeah, FBI files close, they have a certain amount of time. They have a certain kind of retaining period before they release it to the public. But when they do, it may still be redacted because there's information there that might continue to be protected, but they can't hold on to the piece of paper. They got to either give it to you with, either fully available, partially redacted, or, completely redacted, which, is common for a lot of FBI files. You get a whole page that's just completely redacted. So, but the question is are the documents public or not? That's our challenge here.
I still am concerned about the issue of attorney-client privilege and where the line is drawn, and is it a container or is it a
But you see, the point is about exemption. Mm-hmm. Are these? That's where we have to begin. We have to first determine if you're saying it's just attorney-client privilege. The question is the task force really is not here to adjudicate about attorney-client privilege. That is a caveat. That is there's an exception to the rules around public records. Okay, first we have to determine whether the records are in fact public or not, or are they private? Because the public defender is also saying that we are a private law firm, essentially. Mm-hmm. We're funded by the taxpayers because the taxpayers want this service available for people who can't afford to pay for a private attorney. So this is a public attorney that acts as a private attorney to the clients. So the question is the records that they create and on behalf of their clients, are those records actually public? That's our first and foremost question. And go ahead.
So it sounds like you would like to know if someone filed a complaint against another attorney and it was not done in the course of defending a client, would the document recording that be a public document on its own? And if so, it would still be a public document if done during the course of defending a current or future client, but it would be protected by attorney-client privilege. So it's a public document, but it's protected.
Right. Or it's not a public document, period. Like any other law firm, it's not a public document. And then the question is when does it ever become a public document, and when does it become a public document? I mean, these are all important questions for us because this will probably not be the last time that we get a case similar to this. So for us, being able to adjudicate it on its merits, to have some precedent is important for the legacy of the work that we do too. So the question is how far are we willing to learn about this and come to some conclusion versus reaching a certain point where we feel like either we can make a conclusion and bring a recommendation to the full task force where there'll probably be more debate, or we stop short and we just say this is maybe a bigger question that maybe we are just not able to answer, and we maybe a different venue that has more staff and more expertise to be able to come to this conclusion might be in order with regard, because it may be beyond the CPRA. It may go into other complexities that we may not be able to, it's not in our jurisdiction at that point.
So I see that Member Highland has used the raise the hand icon. Member Highland, would you like to say something?
Well, I was going to say that's the longest summary I think I've ever heard, but it seems like we're into the merits of the case. One of the things I saw that we'd already asked for some legal advice. Did we get that or not?
Yes.
Okay.
That was what I told you about the second conversation with Mark Price-Wolf. In the first conversation, he suggested that we talk to ethics, and then Bruce and I talked about that conversation, and at which point Jeffrey Pierce suggested that we go back to Mark Price-Wolf, which I did, and his feeling is that Coronado probably applies in this case.
Okay. I was just hoping for something in writing that would really help our process, and having been part of the case and the index, that written statement from our DC, I think, would ultimately be useful just for future cases that are similar to this. Mm-hmm. That's all I wanted to add.
Yeah, I think that would be important that DCA Wolf does put that legal advice in writing, and if he's if he wants to for it to be discussed, if he feels that it's something that we should discuss confidentially, then let's have a closed session and have that discussion with him.
And to be clear, I asked him. I said, "May I say that you said this in our meeting?" And he said, "Yes." So. Okay.
But still, I agree with Chris that if this is his advice to us, I think it should be. It'll be helpful, as part of the record for the rest of the task force in October, and we're going to have new members also. Mm-hmm. So we're going to need to provide as much information as possible, and if it's in writing, it'll make it a lot. We're going to have a pretty heavy meeting, so it'll be a lot easier for folks to read it as part of the package than having to go sit through minutes or listening to the whole meeting, in audio.
Is that something you want me to ask Price-Wolf to do, or are you going to ask him, Lila? What do you want to do?
I can ask him to do that.
All right. Just make sure he sends it to me, and if it's confidential, tell me that I'm not going to get it, and then I won't include it.
Okay.
It's up to you.
So where are we going with this at this point is really the question.
Well, should we, that is a good question. Should we hear from the petitioner and the respondent to see if there's any new information from either side at this point?
Well, the only concern I have is we've heard quite a bit of testimony. We've heard their arguments a couple of times at least, and I think I'm pretty clear about where they both stand. So if it's something new, that's fine. I don't want to rehash all these issues again. I think we need to start deliberating, and we need to. This committee, I think, we need to kind of either get clear by consensus or vote on a position to recommend, or at least agree on what information that we should push forward so that the task force can finally come to conclusion on this. In the spirit of due process.
Yeah. Just to tie up loose threads, is Mr. Vu there?
Yes. Good afternoon. I am present and listening.
Thank you. So I have a question. In our various discussions, it has been brought up that we could ask you, would you be willing to let either our committee or the task force in some sort of closed session, with our attorney present, and to ensure confidentiality, would you allow us to look at the documents that are being withheld to help us determine whether they are public records?
I think, let me give you a tentative answer, and that's and that's a yes. That's a yes. So, but if you need me to confirm, because that's where how you want to proceed, I can get a confirmation from one level above me. But tentatively speaking, that's a yes. And I'm yes.
Thank you. Members, do we have any questions or comments regarding that answer?
No. I think the only some of the questions and part of the kind of unanswered items that we've just been discussing, I think those need to continue to be part of the thread as we go into this this part. We go into this meeting with those questions still in mind, because we have to be very clear what we're looking for. What is the purpose of going into this closed session? And we want to be very, very clear that when we come out of it, that it provides us with some conclusion, or at least close to it, like enough information to be able to transmit to the task force, so that there's enough substance for them to vote one way or another, or decide one way or another.
Well, it would seem. Sorry.
Board members, if I may raise my hand.
Yes, go ahead.
This is Tyler Booth speaking for the public defender. The other thing too that I would like to sort of suggest is that maybe it would be beneficial to the board if I could submit sort of a list of hypothetical records that we would have. And that way, when you are reviewing this, you would have something that is concrete in terms of what would typically be in the world of the public defender's office. I think that might be good for Mr. Andrews as well, because then at least when we're talking about a disagreement, we're talking about kind of the exact same thing. Whereas now, it seems like what we're talking about are several different kinds of records, and we're kind of comparing apples to oranges in terms of how we treat them. I'm not sure if that's helpful, but
thank you, Member Bruce, or excuse me, Member Wolf.
So I just want to respond to Mr. Vu on that. That I think if going into this closed session, if you could bring those samples with you, so that we can have our legal counsel see them and assure, for the benefit of Mr. Andrews, that they are commensurate with the actual records that we'll be viewing.
Absolutely, we can do that.
Okay, great. And just, yeah, is Mr. Andrus here?
Yes, I am.
Okay, so I think it's important to maybe hear what you have to say about this process that we're thinking about.
Okay, thank you. And I'll be brief and we'll try not to say anything that's already been said. And what I want to do is respond specifically to the legal opinion, I believe, if I heard correctly, Mark Price-Wolf's legal opinion on the subject, which I understood the committee would be receiving following the last hearing to hopefully give us some guidance. From what I heard, though, I have some concerns, primarily because I feel like there's some confusion between asserted privileges. There is an attorney-client communication privilege, and there is an attorney work product doctrine privilege, and they're separate. And attorney-client is I believe when Mr. Wolf said that it was something that even courts can't review in camera, that I would tend to agree with, generally speaking. But it's also something fairly easy to identify in attorney-client communication. It is, it's an email, a phone call, a note. You put who it's from, who it's to, and the date, and that is something that could have easily simply been listed as something that was responsive and yet was covered by the privilege and that they would not be producing, and that would have resolved this issue a year ago. The attorney work product doctrine is a separate privilege. It is not about a communication between an attorney and a client. It is simply something the attorney puts together in preparation for the representation of a client. And I think that's really what we've been discussing here. That privilege can be qualified. And in fact, in that instance, that is when courts do in fact review the documents in camera in order to determine whether the work product doctrine privilege even covers the information at issue. Now, that all being said, what really threw me for a loop was the then subsequent opinion that therefore Coronado likely applies to this case, because I don't know how a decision can apply to anything when there's no basis for a determination. Even courts are, well, first of all, the party asserting the privilege is required, first step, to explain the basis of the privilege. And it's not simply saying Coronado and we're the public defender. It is you have to specifically identify what it is that is being withheld, either through a privilege log, which is simply a list categorizing the specific documents, not just one bucket of category like, hey, all of our files, because that's how we represent clients, and therefore that's our list. No. And to the committee member's point earlier, is it a memo? Is it a newspaper clipping? Is it an email, not between attorney-client, but between attorney and judge, between attorney and reporter, between attorney and whoever? These are all things that need to be identified so that I, as the petitioner, you as the committee members, and perhaps, in the future, a judge can use as the basis to decide in the first place whether or not a privilege or the doctrine exists. So we've completely put the cart before the horse, as far as I can tell, because here we are a year later still talking about whether or not the privilege applies, and yet we still don't have step one, which is a proper delineation of what the public defender is claiming is, in fact, either not a public document and or is somehow protected by a privilege. In either case, whether they want to say it's not a public document or it's somehow privileged, okay, both the ordinance itself and the Public Records Act law on which it is based still require that the responding party, as a first step, meet its burden of identifying what it is claiming it has, but it is not going to produce because it is not a public record or because it is somehow protected by a privilege. We have none of that. And so I understand why this committee is confused, and I understand why the legal opinion is very generic. I don't want hypothetical categories of documents from Mr. Vu. The petitioner, I've been waiting for more than a year. I want actual identification of anything that is being withheld so that I know whether I simply say, okay, I agree. that's something that is not public or is privileged, and I'm not entitled to it, and we can stop arguing over it. But whether or not this committee meets in camera, meets privately, I'm the petitioner. The ordinance is designed to protect the public's right, my right to know what information is out there. And if everything is done behind closed doors or in camera or just covered by a blanket privilege that apparently the city attorney's office is saying, yeah, it probably applies, but to what? Who knows? That makes no sense. There needs to be a list of things that we can say, okay, now that the public defender has basically met its first step by telling us, hey, here are things we're not going to produce because they're not public records or they're privileged. Then we could have an informed discussion, and then we could go down a checklist and get a proper opinion and a proper line-by-line item response as to whether or not this is something that has been satisfied. But
Okay, Mr. Andrus.
We jump straight to privilege. And
Mr.
yes.
Andrus, as I started out, I requested not to re-argue all the points of this case. I'll take your pertinent points.
This is the problem.
I'll take
I haven't argued this point.
I'll take your pertinent points about the privilege log. I think that is important, but your request of the Public Defender's Office was very specific. You're asking for very specific documents. You weren't asking for all the documents pertaining to one or another case. You're asking for communications between the Public Defender's Office and the Bar Association. Is that correct?
No.
No?
Nobody knows what we're asking for anymore because we've talked about Coronado for so long and other issues that simply don't apply. I mean, this is a great discussion. I mean, it's a thoughtful discussion. I appreciate what's being done here, but I asked for records that are specific, and for that reason should not be having to go through this amount of trouble to get an answer. It's when people, if I ask for every record under the sun.
I'm looking at your list of items, okay? Yep. You're asking for documents pertaining to alleged misconduct, okay? In testimony, you had asked for records that of this nature that was sent to the Bar Association.
That was to provide context only because we've gotten to this point. The requests themselves are specific, and the document requests include things like text messages, like emails. There's never been any assertion by the Public Defender's Office that they even bothered to ask any of these individuals, whether they had text messages, emails regarding Mr. Ostley or any of the other individuals named and about alleged misconduct. I did not ask for anything about a client file, a client case. I didn't ask for anything about the bar complaint. This has all come up after the fact because we've been entertaining a response from the Public Defender's Office that simply says everything is covered by privilege with nowhere to start from. So we've been rowing without an oar this entire time because we don't have a list of things they're claiming are either not public under the ordinance, not a public record, or is privileged because of some amorphous, unidentifiable privilege, which nobody can figure out if it's attorney-client, if it's attorney-work product. This committee can't, a judge couldn't, and that's the reason why both the ordinance and the statute require the party claiming the privilege to meet its burden. It's been my burden all along to somehow get over this asserted privilege, despite the fact I have nothing to respond to. And that is what is so difficult. How do you respond to a moving target? Okay, and now even a year later, I'm being offered hypothetical documents, not actual documents, hypothetical categories. What does that do me? Nothing. That is not what the law says I'm entitled to. That is not what the law says that the Public Defender's Office is required to do in response. So I appreciate, again, the time and thought, but it is being given to an issue that is not mine. It is being given to requests that are not in my letter.
Mr. Andrus, please, okay? We're trying to have a discussion here. I'm not going to give you a bully pulpit for it, all right?
We've had discussion. This is our fourth hearing. It's
I
a request.
understand that,
Fourth
but
hearing.
this is our
No
meeting, sir.
decision.
Sir, this is our meeting, okay? You brought this to our body. This is our process. You got to let us have that, okay? I'm sorry you're frustrated about that. We are equally frustrated. We've got 100 other cases to go through too, okay? We can just as well. I can do that. I can just say, hey, look, we can't figure this out. We're going to close the case, and maybe there's another venue that might be more helpful for you. I mean, I'm ready. I'm kind of ready to do that because there's so many open-ended questions here that I'm not sure if I could even explain it well enough to my colleagues so that they can understand it.
So can I just then ask why are there so many open-ended questions? Why have from day one it not been, hey, Public Defender's Office, the ordinance says what it says. Can you just tell us what it is that you're claiming is a public record?
Yeah. No, we have to first determine, sir, I mentioned at the beginning of when we started this that we have to determine whether the records that the public defender creates and collects on behalf of its work is actually public records or not.
But that implies in your question that automatically implies you're saying records that they collect and create as part of their work. That's not, my request went beyond that and simply asks about communications between public employees about misconduct of other employees. It doesn't say that are generated in the course of a case, that are generated as part of your job duties, that are generated as part of a complaint. It can be just communications about lawyers talking about other lawyers. That's all it has to be.
I understand.
But we never even got to that. But
I understand that. But their argument is that they are like a private law firm, and that these kinds of documents are part and parcel to their work product. Okay.
What
now,
documents, though?
Would a private attorney be able to release those same kind of records? That's the question I have. Is the public defender the same as any other private attorney representing a member of the public? Just because they're funded by the taxpayers, what records may be public with regards to them? Their budget, their policies, and how they run their office. Those kinds of things, I would say, yeah, those are pretty easily understood, could be public records. But the question then becomes, is the public defender not in their work, not a public entity for which the California Public Records Act and the Sunshine Ordinance apply? And that's the question that we're trying to answer. And unless we can see what these documents are, we can't answer that question.
But that is my concern, is that they've been allowed to reframe my requests to suit their objection, and we've never identified what the documents are that were responsive to my original request back in July of last year, so that we could have a more tailored discussion. Instead, it has become an open-ended discussion about whether anything that the Public Defender's Office generates is covered by a privilege or a doctrine, but because of the nature of what they do. And that's, well,
we have to consider that every time. Every
you'll
time
never get
somebody
an
brings,
answer.
We know. Well, if we are not able to get to an answer, then we will say so, and we will close the file, and then you'll have to find another venue that can be more helpful. And it could be the Ethics Commission, and their investigative unit are all lawyers, and they may have a better. You might have better luck with them than with us. That's the best I can tell you, and for anyone that brings anything to the Sunshine Task Force, we are limited by our resources. And this is not it may seem not complicated to you, but if we are members of the public and we think that there is, we have to weigh things to the in the interests of the public, well, we also have to weigh at the same time that the public defender is also representing the public. And we have to weigh those kinds of questions at the same time and determine whether that whole department that's publicly funded is a public entity, and or is it part of it is and part of it isn't. You know, those are the questions that were finally coming very clear to us at this point. So I would say at this point, if we had the opportunity to be able to see what documents that they are claiming are not public, or not, if they're claiming that they're not publicly disclosable, we'd like to see them and make that determination for ourselves. We always like to do that because anybody can walk in and cite some law, and if we can't see what it is in order to make a determination for ourselves, we're not so inclined to just take it on face value.
Well, I think what you just said right there hits the nail on the head, and that has been the point that I've been trying to press all along. And forgive me, I don't take for granted the volunteer hours and what this committee does, and so I apologize if I offended anyone on the committee. And I am frustrated, obviously, and partly I'm frustrated is because I feel like it's because of what you just said and the time it takes and the committee's resources that I feel like this has been unnecessarily complicated. It has been made overly complicated for you all as well. And the ordinance wasn't set up that way. It was supposed to be, right? This was supposed to be easy for a public to come in. This shouldn't require city attorneys and 4 hearings and multiple input, because at its heart, it just says, hey, I'm a member of the public. I want to know what's going on. I submit some requests, and you tell me whether you have anything or not, or if you have something but you're not gonna give it to me. Just tell me what it is, and then that way I am informed. So that, to your point, if the reality is there's another avenue or venue I need to pursue to get something, fine. But I will now be informed and have the ability to make a decision whether or not that is in fact necessary or a good use of time or resources, and same as your time and resources. That I don't think that this should have been foisted upon this committee to make this level of decision making. It's policy making across the board when it started out as just some questions about communications by and among city employees about other city employees. And never in both cases, clients, their work product. That is something that's been inserted into it from the public defender's office, and I just want to make that clear that I think that's been a problem all along. And from what I'm hearing at today's hearing, it continues to be a problem because there's a legal opinion that wasn't really fact specific that you're now working with. Questions by committee members saying, "What do we do now?" And I understand this in-camera review may be the solution. I appreciate that. But at the beginning, there should be a list of things that I get to look at to know what everybody's making decisions over, because I don't get to be part of the process. That's all.
Okay, so I just want to make a quick correction, and one is that our legal counsel, while they're provided by the city attorney's office, there's an ethical firewall. So we're not talking about a legal opinion from the city attorney themselves. We're talking about legal advice that is being provided to us by our legal counsel. Okay, so it's not like an official opinion, like a written opinion from the city attorney. I just want that to be clear, okay? Because I don't, everybody's, the parties here are all lawyers, okay? I don't want you to misconstrue what us lay folks may be, saying that in the best way we can, okay? So I think that it's important to mention that. I think at this point, I agree. I think that without much detail from our legal counsel. We don't have in writing what he was thinking or what he was saying, specifically. But I think at this point, if we can go into a closed session, look at these documents in camera, I think that and I've heard this before. Chair LaHood had mentioned it, I think, in previous meetings too, is whether a privilege list is in order, and I think that would be also. I mean, if any documents were to be redacted, every redaction must have a footnote with an explanation as to why it was redacted. If documents are going to be exempted, if they are, if the law allows the contents of a file to be revealed as to the type of documents that are in it, then I think a privilege log is in order. You're not revealing what the detail or the content of the documents are. You're just providing what's in the package. What objects are in the package. So that's really where I'm at right now. It's really just trying to get down to the brass tacks here, and then the question. I think my last question would be, is what part of the public defender's office is independent and exempt from, if at all, from the California Public Records Act and the Sunshine Ordinance. And frankly, I may have missed it, but I have not seen a citation around that.
I have one more question for Mr. Vu.
Yes, I'm present.
And actually, you know what? Forgive me, I was looking at the wrong. Actually, my question is not relevant, but I will ask one more time. Would you be willing and able to provide a list of what types of documents that are being withheld in each category?
Yes.
And would you provide those to Mr. Andres, or are you saying providing them to for review in a closed session?
No, I think that I would review the documents and I would provide those documents, those types of documents to Mr. Andrews. Yes.
Okay, so I think it sounds like he is asking for and would appreciate receiving those things specifically.
Sure, we can definitely do that.
Okay, so I would like to ask you to provide that list to Mr. Andres as soon as possible.
Okay, it's going to take me some time because he has another CPRA that he's logged with my office that we're working on already, and so I've got. So yes, we will work on it as soon as possible.
Mr. Andres, how does that sound to you?
It sounds good in theory. Thank you.
Okay. I feel like we're making a little bit of progress.
Right. So the other questions, beyond just figuring out whether the documents are public or not, is there other parts of the ordinance that have been violated? Is there an allegation of, are those out? We have to deal with any of those other allegations with regards to timeliness and whatnot. I think there was these were IDRs.
Yes, I believe so.
Excuse me, folks, I hate to tell you, but I've lost my computer connection. So just,
You can still
So you can't take notes?
I can't take notes, yeah. It's just, I've lost my connection.
All right. Well, you'll have the audio.
Yeah.
Guess it's the best, better than nothing. Yeah, I don't recall. I do have a question on this. All right, if there's anything else that you want to discuss, I'm going to look. I'm just going to quickly. I don't have my notes from the previous meeting on this one. Yeah, I don't think.
I'm looking at this. I don't know that it was an IDR.
I don't. It is. I believe it was. I mean, in our memo on page. Yeah, the original complaint was failing to respond in a timely and complete manner.
Right. Right, because there was not a response within 10 days. So.
Right. So we'll make note of that for the task force. We're not adjudicating this here. We're just trying to create a record and create a report to the task force so that they know what we've been reviewing and to take note of.
In terms of, go ahead.
No, that's it. It was just the timeliness issue.
So in terms of procedure, at some point this has to go to the full task force. At some point we have to request and arrange a closed session to review documents. Mr. Vu has agreed to provide a privilege log to Mr. Andrews describing the documents that are being withheld in each of the categories. How can we proceed to make sure all these three things happen as quickly as possible, and in what order do they need to happen? It seems like the reverse order is required.
Yeah, I would agree. But I think we should try to get that closed session before the task force meeting in October. Oh, no, that's
Agreed.
Next week. Can we do that in a week?
I think we can do it because it doesn't have to be, if it is not.
Oh, it's not going to be on the October agenda, is it? Is this on the October agenda?
No, I thought we were going to come to a conclusion today, but I can put it on there. I mean, after today's discussion, I kind of think we need to.
Yeah.
Yeah, I would say so. So let's put this on the October agenda. And then what we'll have to, if you can call DCA Wolf and arrange for a time and then communicate with the parties and see about getting this together, and then we have to develop a procedure for this, because if we're going to want to consult, so just theoretically, we go into the closed session. Is it that the documents how do they get delivered? How do they get presented? And then if we want to have discussions with our attorney, then the respondent can't be present, because that discussion will be protected by attorney-client privilege, because we'll be meeting with our legal counsel in closed session.
Okay.
So I just want to make sure that we kind of understand, we develop whatever ground rules there are for going into this closed session.
Is this closed session going to be prior, like at 3:30, 3 o'clock on that Wednesday before the task force hearing? Is this
No.
would you like me to arrange, or how would you like me to do this?
No, it has to be. It can't. I don't know. Lila, what do you? Chris, what do you think? I'm thinking it should be a little sooner.
I mean, sooner would be better. However, I could understand how logistically, if we are meeting anyway and we have a forum for meeting and can include those who should be included and provide a closed session and not allow others into the session until we're finished with the closed session.
So we have all the rest of this week and all of next week.
Mm-hmm.
Okay, I think we can all find a time to be able to do this.
So it's the three of you, Mr. Vu and Mr. Andrews, and Price Wolf.
Not Mr. Andrews.
Okay, so Mr. Vu,
It's Mr. Vu.
Mark,
Right.
and then the three of you.
Mm-hmm.
Right. And then, this is for the purpose so that the task force, that we can help the task force make a decision about these particular type of documents. Can somebody please mute their phone? Thank you. So I think so. I just want to, maybe after this meeting, if you can contact Mark and ask him what an appropriate process might be in order to protect the information and protect the process. Lila, what do you think about that?
I think that sounds like a good plan. And I would also like to request that we receive a copy of the privileged blog that is going to be sent to Mr. Andrews. I think that would help us to have as part of the case file for this as well. Member Highland.
Not to beat a dead horse, but if DCA Wolf said you could quote him in this meeting, I would think at a minimum it'd still be nice to get that memo as part of what we see, what the full task force sees. I think we still need that before we go anywhere. I don't think this meeting should have even taken place today without that. It was clearly listed in the last minutes. That should have been the starting off point for this meeting. I hate to say it, but I think we need that opinion to then go into any closed session or back to the full task force or anything. I think we're still at a roadblock. I'm not convinced that we're otherwise.
Well, we can only move forward at this point. So let's get those. I agree. I think that should be in writing. But I think what we'll probably get a better idea come this closed session about what he was thinking once we see the documents and we can have that discussion. I'd like to move on.
Okay, do we need a motion on how we're going to proceed with these various steps?
Yeah.
So
I'll move that we affirm that the respondent has agreed to provide a privilege log to the petitioner of the items that were requested, that are noted in the record and in his request, and that we arrange for a closed session to review the records in question, to determine for the purposes of obtaining information that would help the task force make a determination whether these records are in fact public or not. And that will, go ahead.
I was going to say, do you want to add anything about the memo from DCA?
Oh, right. And that we receive written legal advice from our legal counsel on this matter.
So I'd say that would be the log, the written advice, and then the
Closed session.
in that order.
Yeah.
Who's going to second?
I'll second that.
Is there any public comment on the motion from parties not involved in the case?
Yes.
Please go ahead.
Hang on.
Yes.
Oops, hang on. Wait,
Sure.
please.
Let me know.
You may begin.
Thank you. Anonymous here. Of course, nothing I say is legal advice. So the respondent stated something very troubling while you guys were discussing how much of this would be attorney-client privilege or how much of this might not be a public record. And that is that they would essentially be okay showing your members these supposedly attorney-client privileged documents. And as far as I understand, if they're truly attorney-client privileged, they can't even show them to you, even in a closed session. And that makes me believe they're not truly attorney-client privileged. They might be privileged under somewhere else, something else, or confidential under something else. But it's the attorney-client privilege, which is essentially absolute, and not necessarily all the other rules of exemptions, withholdings, or privileges, only the attorney-client privilege. And it is also troubling that we've heard things about, kind of balancing the burdens. And under the Sunshine Ordinance specifically, the entire burden is on the respondent, as you've discussed in many other cases. There is no burden on the petitioner to kind of prove that these records aren't truly attorney-client privileged, because the petitioner really has no way of doing that. And the fact that they didn't initially respond with telling which privilege for each of the requests, because there's many requests if I remember this case correctly from a long time ago, they didn't say which privilege applies to which set of documents. And that kind of allows them to take the Coronado ruling or the attorney-client privilege, which are much broader, protections, and kind of sprinkle them up across all the documents. And that's really should not be allowed. And while it's great that the task force has kind of coming up with a creative way of solving this problem, I do hope that you comply with the Brown Act rules for closed sessions if they apply to this case. And I wouldn't think that the respondent only would be allowed to come to your closed session. They would somehow have to submit it separately, and then the only people at the closed session would be you and your attorneys, and it would be agendized and kind of noticed. You would tell everyone that you're doing it, but it's in closed session. I don't know if those rules apply to this kind of meeting, but I do hope that you get advice from your legal counsel about making sure this is done in a fair way so that the respondent doesn't have any advantages. Thank you.
Is there any additional public comment? Seeing none, do we want to take a vote, or
Yes.
is there? Okay. Let's call the roll, please.
Member Wolf?
Yes. Aye.
Member Wolf, aye. Member Highland?
Aye.
Member Highland, aye. Chair LaHood?
Aye.
Chair LaHood? The motion passes. Next item. We ready for the next item?
Yes, please.
Thank you, parties.
Item number 5, file number 19119, complaint filed by Anonymous against the Department of Technology for allegedly violating Administrative Code Section 6721B, 6726, 27, by failing to respond to a public records request in a timely and/or complete manner.
And are both parties here?
This is Linda
Petitioner
Jarrell
is
with the
here.
Department of Technology.
Okay, so this is a hearing to find jurisdiction and to make sure that we have this is a hearing on jurisdiction and to see if we have the appropriate materials.
We need a correction. Jurisdiction was decided back in January due to the 45-day. Do you remember that? Yes.
Yes.
And so we
Yes,
are
yes,
determining if the records are public and should it be forwarded to the task force. Those are our things we have to determine today.
Thank you. This is correct. So we would like to hear from the petitioner first.
Okay.
Sure, let me know when to begin.
Okay, hang
Hang
on.
on. Yeah. Go ahead, sir.
Thank you very much. Hi, this is Anonymous, the petitioner in this case with the Department of Technology. Thank you, Chair and members of the committee. So this case is a pure electronic metadata case regarding email and calendar entries of the Chief Information Security Officer, Michael Maxman, and the Chief Information Officer, Linda Jarrell. And I believe Ms. Jarrell is on the line to discuss metadata in more detail. This came in October 2019. At the time, DT refused to provide the requested metadata, and I filed this complaint. And as your other members discussed in the similar complaints that are now coming before the committees in the complaint committee last week, this has been discussed quite in length. Your IT committee held maybe 3 hearings on this issue and recommended that, yes, metadata is a public record. Yes, you have to treat it like everything else. Burden is not an excuse, and you have to justify why you don't provide whatever you don't provide. From October through February, DT, Ms. Jarrell and Mr. Maxman have actually worked with me to draft various recommendations on what exact metadata can be released, what can't be released. They've been very gracious to do so through a numerous amount of meetings until kind of coronavirus started, and that kind of was all left on hold. And we've kind of restarted those discussions, I believe, last week. And I believe Ms. Jarrell is going to actually discuss some of that with you here. If you remember your last order about metadata, where the city attorney's office was ordered to turn over some email headers, in one of the comments from your chair, Chair Wolf, was the city should develop a baseline of what actually can be released and can't be released. And I believe that's what DT is now in the progress of doing. And I thank them for doing that. I hope they're going to talk about that in a little bit. However, I will remind you that in this case, the actual records have not been turned over to me, and I hope they are turned over, just these ones, before we get to the whole baseline, in the minimally redacted fashion, and then you can actually discuss at the full task force whether that was appropriate, like you did with the city attorney's office. And again, I do want to thank Ms. Jarrell and Mr. Maxman. Unlike some agencies, they've been actually very cooperative in trying to figure out how to get to this solution where the whole city can provide metadata correctly. That's it. Thank you very much.
Thank you. And I think we're almost ready for the respondent.
Yeah, good.
You have something to say, Bruce?
No, I'm good.
I haven't started the clock. All right, is the respondent ready?
Yes, I'm ready.
Oh, all right, you may go ahead.
This is Linda Jarrell, and I'm the director of the Department of Technology and also the city CIO. And Mike Maxman, who is the city Chief Information Security Officer, is also on the line and can speak to this. As you know, we had conversations about security concerns around releasing metadata that included fields that could be used by hackers to access or try to hack into city systems. Of course, that's a concern for the city, and we are seeing, even during the COVID crisis, a dramatic increase in hacks and attacks on the city. So we are particularly concerned about this, but we also understand the need for visibility into data fields that would be of use to a requester. And so what we have been doing over the last month, besides fighting COVID, is defining what those fields would be, identifying the specific fields that are sensitive. We are applying standards to this process, and we want to build a document that could be used as a guide for departments in the city to use. We also know that redacting this data could be fraught with inconsistency and is difficult, which totally defeats the purpose of trying to provide it and could preclude providing it. So in certain situations. So we are also looking at what types of technology tools could be applied to make this easier for the public request person who is trying to fulfill the request. So we will continue to move forward. I will say that we are working as we speak, I'm looking at it on the screen right now, to partially fill the request under 19119, and we'll continue our conversations on what is standard, and hope that we'll be able to correctly and adequately socialize this throughout the city to make sure we have a broad perspective of comments and situational awareness from everyone that's involved before anything would become final. So, Mr. Maxson, would you like to comment?
Thank you, Linda, for this introduction.
Excuse me for just, Lila, did you get 5 seconds, 5 minutes now?
Members?
He's the name,
right now,
he's actually the named party.
Does he get more? He's
a named his own 5 minutes.
Give him 5 minutes. Yeah.
Give him 5 minutes. All right, hang on.
Sorry,
ahead,
Mike,
sir.
if I took your time.
No, he didn't. He gets his own 5 minutes. He's fine. Go ahead, sir.
Thank you. I will be brief, so not all 5 minutes will be used. I want to add that to understand how we can release the metadata in a safe way, we have analyzed internet standards for email and calendar message headers to understand the purpose of each of the metadata field, and have created an initial green list of metadata message header fields that that do not compromise risk and security of the city. That green list includes majority of the fields. Exceptions may be specific references to security tools or technology versions of the city systems, as well as fields that are not part of the standards and are introduced by vendors such as Microsoft and Google, where there are no description of what the field actually contains. It has encoded data or data that is relevant to the system, but still may introduce, because of its unknown quality, risk to the city. We are also are in agreement that the field names themselves can be released, and are continuing to refine our standards, which we're planning to release for review by the city attorney and by the city administrators, and then finally to IT directors and city departments in a very near future. The anonymous statement that we have been working together in partnership is absolutely correct. We enjoy that partnership, and we had to take a break for COVID-19 support of the city, and we're back on track to release the standard and to start producing documents in accordance with the standard as soon as we have it finalized. Thank you.
Yes, and I would like to also add a thank you to Anonymous, who has been helping and help us understand the needs of the requester, and we certainly appreciate his time.
Thank you. Okay, so we've heard from the petitioner and the respondent. Members, do we have questions or comments?
I have a question for Anonymous. You're pretty assertive in your communications to us that you feel our IT committee should hear this. Why do you think so?
No, I don't believe that at all. And if I spoke that, I completely misspoke. What I was trying to say is I'm assertive that you have already heard it many times, the full discussion. Ms. Jarrell was there, Mr. Maxman was there, numerous other city department heads or something were there. I'm saying it's time now to let the normal process go. I apologize if in any way I said it should go back to the IT committee.
Okay.
That may have been months ago that I sent that email. That's like long time before that process.
Okay.
So.
Yeah, it was, November. It just said, this is a new complaint. It should be sent to the IT committee for metadata.
Yeah.
So that's why I was.
Yes, at the time you had made a ruling at the full task with you as chair that all of these should go to the IT committee until the IT committee can make a decision on the metadata, and then you did. I apologize for the miscommunication.
Yeah, no, that's fine. That's fine.
I'm actually, I would say I'm glad to, having participated in some, if not all of those IT committee hearings, I'm glad to hear that there's been some progress on this front.
So I have one more thing. I'd like to ask Ms. Jarrell and Mr. Maxon if they would be so kind as to include the Sunshine Task Force in either the creation or reviewing of those guidelines.
And Mrs. Linda Jarrell, and that was definitely the intent.
Okay, very good. We appreciate that. Okay, so I don't know what.
I guess a question in for, as I was listening, it sounds like much of what's requested has been handed over, and the rest is in process. Is that a correct assessment of what's been happening with this case, with this complaint?
No, I haven't. Wait, sorry, was that to me or was that to Ms. Jarrell? I apologize.
Actually, it's to you, Anonymous.
No, I believe what Ms. Jarrell was saying is they're now in the process of doing it, but they haven't given it to me yet, and that they would hope to do so soon. Ms. Jarrell can correct me, but yeah.
That's correct.
And this was all pre-COVID anyway, way before. We're dealing with it at that particular period of time at this point. So the question before us is the information public?
Yes.
And if is it within our jurisdiction? That's really what we're about here today, and if there's any other information to push forward to the task force, I guess. So I'll move that. I move that the information requested is public, and within jurisdiction of the Sunshine Ordinance.
I'll second.
And move it forward to the Sunshine Task Force for scheduling.
I'll second.
Is there any public comment on this motion by anyone not involved in the case? Seeing no public comment, please call roll.
Sorry, guys. Member Wolf?
Yes. Aye.
Member Wolf, aye. Member Highland?
Aye.
Member Highland, aye. Chair LaHood?
Aye.
Chair LaHood, the motion Send to the full task force passes.
Thank you. And please call the next item.
Thank you, parties.
Item number 6, file number 19121, complaint filed by Anonymous against the Police Commission for allegedly violating Administrative Code Section 6721B, K, 26, and 27 by failing to respond to a public records request in a timely and or complete manner, withholding more than the minimum, and failing to justify withholding. This matter was also, jurisdiction was determined on January 28th before the Compliance and Amendments Committee.
Thank you. Thank you very much. Are both part of, yes, Member Wolf, you have a question?
Just a point of order. Cheryl, you mentioned that it's that we had determined that it was within our jurisdiction. It really was the 45-day rule, right?
Yeah, I mean, that's what the minutes said, but I just
Okay.
try to condense it.
Yeah, but it's the 45-day rule is really the important part because that's the requirement that we are to act
Within
in the
45
ordinance.
days.
Yeah, there's really, the jurisdiction part is really our own edification. What it does is it really helps. They may be public records, but they may not be applicable to the Sunshine Ordinance. So, that's the purpose of adding the jurisdiction part. So we're not, wasting everybody's time.
Yeah.
So I'm sorry. Continue.
Unfortunately, for some people, having had jurisdiction, for some of the petitioners, they felt that they could go bypass the committee process and go straight to the task force, and it took some convincing for them to realize that we need to have a hearing on the merits of the case before anything ever goes to the task force.
Yeah. Okay. Thank you.
Okay. So we're here today to have a hearing on the merits of the case. Are both parties present?
Petitioner is present.
Is respondent
present?
I'm sorry, who was the respondent?
This is Sergeant Youngblood from the Police Commission Office.
Oh, yes. Hi, Sergeant Youngblood. Yes.
Thank you. So we will first hear from the petitioner. You'll have 5 minutes when Ms. Leger gives you the all clear.
The go?
Yes.
Anonymous, go ahead.
Thank you very much, Clerk, Chair, and members. This is case 19121 Anonymous versus Police Commission, and in the actual caption, it should have the named commissioners. At the time this September request happened, I think many of them aren't even on the Police Commission, but they are the individual respondents in this case. We can begin on page 79 of the PDF. There are no footer page numbers. We're just going to do PDF page number 79 for item 6. Last September 11th, I made an IDR for certain communications of each commissioner and the secretary of the Police Commission. They gave an initial response within the IDR timeline saying it was not simple or whatever it says in the IDR rule. Then they gave rolling responses between September 18th and October 4th. The withheld documents were not justified in any way in writing, and that's a violation of 67.27, nor did they even acknowledge that they had withheld any information. They also redacted various documents and did not provide any footnotes or other clear references to justifications, which is a violation of 67.26. In fact, I don't think they provided justifications at all. It's not just that they didn't give me footnotes or clear references. There just wasn't any justification. On November 9th, after waiting a substantial period of time after the rolling responses seemed to have finished, I filed this complaint both before the SOTF and the supervisor of record as a separate petition. On December 3rd, the Commission admitted in a response to you that approximately 40 of, and I think 50 of the alleged unlawful redactions were in fact wrong, and they corrected some of them, but not all of them. You can see an excerpt of the request at the bottom of this page. Next page, please. So the first issue is the redactions and withholdings were not justified at the time of the filing of the complaint, which is what matters. And neither did they justify the entire documents or information withheld, nor did they justify the redactions. Even after the complaint, it seems that the Commission believes they only have to justify the redactions that we named them, like, oh, on this page, this redaction. That's not what the law requires. The law requires every redaction and every withholding to be justified. And if they're not willing to justify why they're withholding all this information, you should order them information released at the full task force. And why is this important? Because we challenged only 50 of the withholdings. They didn't justify any of them. And 40 were admitted to be wrong by the commission. And what this shows is when the city does not have to follow the rules about justification, they can easily over-redact because they can be sloppy, right? If you don't have to justify each and everything you do, you can do whatever you want until someone holds your feet to the fire. And that's why the Sunshine Ordinance requires justification of withholding information and every redaction be justified. Now, in later records requests, this was a year ago, they seem to have learned their lesson. So for example, this is what they do now, where they give an index of all possible exemptions, and each and every redaction has a number of which exemption applies. And that's what the law requires. And the last issue, if you look at the next page, is, and that's, I think, 6721K. These records are not actually copies of the original records. What they've done is taken emails between the email that I requested, then forwarded the body of that email to the secretary or the public records person, and then the public records person makes a copy of that email. You may wonder, why do I care? Because you lose attachments, you lose formatting, you lose even things that aren't email headers. Of course, you also lose things like when someone sent an email, when they received an email, when what you're doing is forwarding the actual responsive record to someone else. And I believe those are the issues for this case. Thank you very much.
Thank you. Is the respondent ready?
Yes.
Okay.
Okay, wait one moment.
Go ahead.
So I basically agree with what Anonymous said. We did over-redact some of the documents, and we have gone back through them and unredacted them. We have had a training within the commission office on instituting an index, and we have re-released the documents. And if I'm not mistaken, this is quite some time ago, but if I'm not mistaken, there was a list that Anonymous provided where he listed out each item that he was talking about that he was challenging, and we responded to just those. We must have mistakenly thought that that was what he was prioritizing, that he wanted the index of and what the redaction was for that. So I think there's a little bit of miscommunication between the two of what we were releasing and unreleasing, but the commission office going forward now does provide an index. We have provided training on public records redactions, and we do admit that we over-redacted at first and tried to remedy that.
Is that it, sir?
That's it.
Oh, okay, great. Thank you very much.
Thank you.
I just have a curious question for Sergeant Youngblood. What compelled you to go back to the original redactions and determine that they were over-redacted?
I can't speak for the police commission secretary at that time. I really don't know.
Okay, I appreciate it. Okay, thank you. That's all.
Do we have any other questions or discussion, members?
Nope. I'll move that I think we have everything that we need here, and forward it for scheduling to the task force.
Okay, so the records are public, we're determining jurisdiction, and it's going forward.
Well, I thought we already determined that it was public.
Yeah.
So we don't need to review that. We're trying to complete the file and get an understanding and clarity of the case here. So I think we're clear. I think we have all the information we need. I think it's ready to go to the task force.
Do we have a second?
I'll second that. Yep.
Okay. Is there any public comment on this matter by members of the public who are not involved with this case? Seeing no public comment, please call roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Highland?
Aye.
Member Highland, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Motion to send the case to the full task force passes.
Thank you. Thank you, petitioner and respondent, for being here today. Let's call the next item, please.
Item number 7, file number 19112, complaint filed by Anonymous against Chief William Scott, Lieutenant R. Andrew Cox, and the Police Department for allegedly violating Administrative Code Section 6725, 26, 27, by failing to respond to an immediate disclosure request in a timely and or complete manner, failing to justify withholding of records, and failing to maintain a Prop G calendar.
Okay, thank you. Do we have are both parties here today?
Petitioner is here.
Good evening. This is Lieutenant Andy Cox.
Thank you. And Member Wolf, you had a question?
Yeah, just a point of order. Can we have the activity around this case that's already been done read into the record?
Oh.
Please. Thank you.
On September 2nd, 2020, the Sunshine Task Force found a violation of Sunshine Ordinance Administrative Code, Section 6725, for failing to provide the requested records in a timely and or complete manner, Section 6726, for withholding all future calendars instead of providing them with minimal redactions, and 6727 for incorrectly citing 6729-5 for withholding non-Prop G calendars, and referred the matter to the Compliance and Amendments Committee.
Okay, so it's already been adjudicated. This is compliance, right?
Right.
Okay.
So
Yeah,
since
that was earlier this month.
So since this has already been adjudicated and we're looking at this for compliance, I believe, let's hear from the petitioner first. You have 5 minutes to speak.
You ready, sir?
Sure. So, yes, I am.
Go ahead.
Sure. So this is a somewhat unusual case. So what happened was the petitioner and respondent came to you a few weeks ago saying, they basically said, yeah, we agree with this. And you guys said, okay, well, both parties agree. Let's make the ruling, and let's go home. And it turns out there's a letter issued. I don't know if it's because there's no 5 business day rule for this kind of hearing, but I don't think we weren't informed of one. But I believe the respondent has sent you a letter that says no, they made a mistake, or he made a mistake, but not SFPD and Chief Scott, that they will not provide future calendars. I want to be clear. You have already ruled that future calendars are disclosable and they need to be minimally redacted. I think you should follow through on your ruling. And it's extremely frustrating that the legal arguments that the respondent now wants to raise were not raised at the hearing. I don't think it's appropriate for them. If you were appealing in a court case, you have to raise the issue on the first time you discuss the issue. You can't, you lose and then say, well, I have a whole bunch of new issues I want to raise before the appeal. I know this is not an appeal, but I think you should continue forward with exactly what you've held. You've held it in the past. It was a unanimous ruling both this time and years ago when you held it that time too. Future calendars are a public record. They need to be minimally redacted. And another person came before your complaint committee and made the same arguments that the respondent is about to make in a second, which is because this is all from Dennis Herrera's office, and that's how this happened, which is that, well, this Times Mirror case allows you to completely withhold the record. That's not true. As at that time, Member LaHood asked Hank Heckel, who was the compliance officer for the mayor, well, why can't you provide some of the record instead of the whole record? And what Hank Heckel told you then is true for this case as well, which is if they removed the location and time and date and time and just gave the rest of the Outlook entries, which describes what is being discussed, attachments, the communication that made that meeting and who's going to be discussing those things. Those things the public has a right to know. There's no reason to redact them. If you want to protect the security of the chief, then don't tell us where he's going to be ahead of time and when he's going to be there. But the topics of discussion and who the chief is meeting is not about his security. They are trying to protect his deliberative process privilege. And the deliberative process privilege is banned in the city of San Francisco, even under the COVID-19 emergency rules. So you should not allow them to hide what the chief is going to discuss, what he might discuss, who he wants to discuss it with. If they want to keep him safe, take out the time, take out the date, and take out the location, just like what was discussed with Hank Hickel and the mayor. Thank you very much.
Thank you. Is the respondent ready?
Hang on.
Oops, hang on.
Can you hear me?
Not yet.
Yes. One moment, please.
Go ahead, sir.
Okay, sorry about that. I couldn't get my mute off. Anonymous is right, and I do want to apologize to the committee. Going back to September 2nd, 2020, when we were in full session, I was specifically asked regarding whether we would release future Prop G calendars, and I did answer yes. I apologize for causing any confusion regarding this. When I provided the answer, I did not mean to infer that SFPD would waive any rights to exempt Prop G calendars in whole or any portion thereof if warranted. The SFPD will continue to apply exemptions and exceptions to the chief's calendar, future calendar entries that have not yet occurred under CalGov Code 6254F, CalGov Code 6254K, Cal Evidence Code 1040, and as Anonymous brought up, Times Mirror Company versus the Superior Court. I understand from hearing from Anonymous that he's saying that one is not fit as to a prior hearing, which I've not heard about, Anonymous, so I apologize. But that is our stance at this time, and I do apologize greatly for any trouble that I have caused. And as I said in my letter, this is my own statement, and if there is any consequences for it, it should go to me and not the, Chief Scott or the SFPD in general. That's it.
Okay. Thank you, sir.
Thank you. Thank you. So I am seeing Member Wolf has a comment.
Lieutenant Cox, I'm a little confused. Are you the actual respondent in this case?
I'm one of the respondents, yes, sir.
And you are making this decision on behalf of the entire department and the chief?
I'm sorry, are you saying specific? Well, with the advice of counsel, I am also citing this, yes.
But you said that the very last sentence you said was that you are making this.
That I made a mistake. Oh, sir, that I made a mistake.
Okay.
I am saying I take full responsibility for that.
Yeah, right, but you're basically stating that the decision for not providing future calendars or information on future calendars is your decision.
Well, based upon counsel, yes. That is the department's position.
Okay, and I mean, I'm just trying to figure out. I'm not quite understanding what your role is in this, with regards to the chief's calendars. They're the chief's calendars.
That is true. They are the chief's calendars, but my office, I'm the officer in charge of the legal division, so I handle things that come out of the office and go to, say, Anonymous. When Anonymous puts in a PRA request, that filters through my office first.
Okay, fair enough. I just wanted to get clear on that level, because when somebody says that they are making that decision individually, I just want to be clear for the record what role you play to be able to make that decision, and whether you're making that decision based upon your own beliefs or your own, experience and expertise, or you're doing it as citing some area of law, which you did. And so I'd like for you to, now that you've reversed your decision, which was, what we found you'd be in violation of, tell us now why you think these particular statutes are applicable.
Well, as we said before, Chief Scott is the head law enforcement official for the San Francisco Police Department. Releasing his future calendars can greatly, jeopardize his security. And we, as SFPD, we are required to protect him. Releasing the information from his calendar relieves the timing and details of his whereabouts, as well as the patterns and habits of the chief of police. While we're cautious to release his calendars at all under laws, we have done so only after we do careful review. And these are, this is talking about past calendars versus future. This careful, when we look at it, we have to look at it from, going backwards. I understand that Anonymous is saying if you, do minimal redactions, that his security is not in danger. He's not in danger for that, but I disagree.
Well, I want you brought up 3 specific sections of law as your defense for now reversing your decision and now withholding. Can you speak to each one of those statutes as to how those statutes specifically apply? I mean, I'm reading those sections. I have them right in front of me. I'm reading the black letter law right now. So
okay.
I would appreciate it if you could do that, because that's really your burden at this point.
I understand. And you do have to, I have to apologize, sir. I am a layman in this. I'm not a licensed attorney.
Well, so I'm a little confused now. You made this decision based upon this section of law, but you're...
And based upon...
Okay.
Based upon, and as I said, based upon counsel's advice.
Okay. Very good.
Okay, so if I misled you on that, I apologize. But no, it was based upon counsel.
I understand that, but just citing a section of law and saying we're not doing this because of this section of law without any explanation is not helpful. I mean, we have to make a decision based upon whether you are applying that section of law correctly or not. If I'm giving you an opportunity to be able to walk us through each of these sections to tell us what part of them caused you to change your mind. And if legal counsel is providing you advice, ultimately you make the decision, not the legal counsel.
And that is correct. And my counsel is supportive of that, of my decision,
Okay.
and is willing to argue it. I'm sorry, did I lose you?
No, I'm here. I'm actually waiting for a response.
No, I'm sorry. I said that, it was advice given by counsel, and counsel is, prepared to fight that fight if needed. As I said, I could tell you that just, 6254F, this is a security record. There would be a security risk if these future calendars would released.
I hear what you're saying. I hear you, but the way the ordinance is written and the way it has been not just adjudicated with us, and the reason why the laws were created and actually well reviewed and studied is that public officials at his level, the public has a right to know who they're meeting with. And I'll tell you one good reason why. The ordinance has a section, it's at the very beginning of the ordinance, where it talks about specific kinds of meetings. And if a public official is having a meeting with a party regarding a decision that the public official will be deliberating or making a decision on. The other members of the public and other people that might be part and parcel to that decision have the ability to attend or receive notes and know when that meeting is happening. Now, the chief of police is an administrator, and his role, he or she or they, their role is to do the public's business, and some of that business must be done in the public's view, and whether it is done in person or whether it's done by the release of records. The bar for calendars has been pretty clear. I mean, this is not novel. This has been ongoing for a very long time. So I'm not quite convinced of your defense here by just citing sections of law without any further explanation as to how they exactly apply. And just calling it a security file is not enough. I mean, even in the last case with regards to metadata, we're talking about parts of it that may be not secure enough for release to the public. But it doesn't mean the whole thing goes away. And so, and I think the petitioner here was very clear in that he wasn't necessarily looking for all the gory details, but wanted to know what the subject matter was. What was this meeting for? Who are they meeting with? Is it a meeting with the union? Is it a meeting with a contractor for, cleaning up the office? Is it, those kinds of things? And the public has a right to know, with regards to the calendars, that kind of information.
No, Commissioner, I can appreciate what you're saying, and I understand that.
So
I think those. Oh, go ahead.
Please finish your statement.
Oh no, I'm just saying. No, I completely appreciate what you're describing in that there may be ways to redact the calendars, minimally to get everybody, get what the respondent, what the petitioner would like. That is something I will definitely have to come back on. That was, when discussing with counsel, that was not an option. I can always go back and re-examine that. But I will not, I won't make that decision now because obviously I do not want to mislead the commission in any way again.
So, I'd like to challenge you on this a little bit. In section 6254F, in the middle of the paragraph, and I'm just scanned it, so I'm going to read it. Maybe I've misread it, but I think it speaks to it. It states, however, now I'll read the paragraph. It says records of complaints to or investigations conducted by or records of intelligence information or security procedures of the Office of the Attorney General and the Department of Justice, the Office of Emergency Services, and any state or local police agency, or any investigatory or security files compiled by any other state or local public agency, or any investigatory or security files compiled by any other state or local agency for correctional, law enforcement, or licensing purposes. However, state and local law enforcement agencies shall disclose the names and addresses of persons involved in or witnesses other than confidential informants to the incident, the description of any property involved, the date, time, and location of the incident, all diagrams, statements of the parties involved in the incident, the statements of all the witnesses other than confidential informants, to the victims of an incident or an authorized representative thereof, an insurance carrier against which a claim has been or might be made, and any person suffering bodily injury or property damage or loss as a result of the incident caused by arson, burglary, fire, explosion, larceny, robbery, carjacking, vandalism, vehicle theft, or crimes defined in subdivision B of section 13951, unless the disclosure would endanger the safety of a witness or other person involved in the investigation, or unless disclosure would endanger the successful completion of investigation or a related investigation. However, this subdivision does not require the disclosure of that portion of those investigative files that reflects the analysis or conclusions of the investigating officer. Customer lists provided to the state or local police agency of an alarm or security company at the request of the agency shall be construed to be records subject to the subdivision. Notwithstanding any other provision of the subdivision, state and law enforcement agencies shall make public the following information, except to the extent of disclosure. And it goes on to with a whole list of items that should be disclosed. I don't understand how a calendar fits into this definition.
Well, I think actually you kind of read it right there. It says, except to the extent that disclosure of a particular item of information would endanger the safety of a person involved in the investigation. That we are claiming, but that's what you're asking, and we're saying that that is by releasing that information that is endangering the safety of the chief of police.
Yeah, but if there is an entry in a future calendar that you know in fact is part of an investigation or a related investigation, you would be well within your rights to redact that, but not withholding of the calendar completely. That calendar is a public record if it is created and if it exists. And the only calendars that are not disclosable are personal calendars. And because of cases like this, the city has adjusted, everybody's adjusted to take all their, to have two separate calendars. A person has their personal calendar on their body, and they have their business calendar in their office that is managed either by themselves or their staff. And they need to talk to each other as to, can I book an appointment at this time? No, I can't make it there. I have a doctor's appointment. That's not disclosable, the doctor's appointment. But the meeting that they're trying to create in the course of doing business that they're getting paid for with taxpayer dollars is public business. And the people have a right to know what their public officials are doing, every day of the week, every moment of the day, pretty much. So I'll stop there.
Yeah, and even just to add to what you're saying, if for security reasons you needed to redact the location or the time or even the date, it doesn't mean that the rest of the information can be redacted.
No, I see your point, but I hate to use the term respectfully disagree, but at this point I do.
Right.
May I show the members just page numbers, if I may?
Please. Go ahead.
Okay. So I'm just picking random pages from item 7. So page 147, right? This is Fleet Week press event at DEM. So let's say this was in the future, right? And let's say that I don't concede it, but let's say you were to agree that to protect under one of these rules, and I don't know which one, I'm not going to tell them which one, but under some legal citation, they could remove the fact that it's 10:30 to 11 a.m. and the fact that the chief would be at DEM, maybe that's fine. But the fact that he's doing something with Fleet Week is not a quote investigatory record. It's not a security record. It's not law enforcement. There's another. I'll just give you another example. I think it's page. Hold on 1 second. Page 140. Right. This is a weekly meeting with Mayor Breed, and it discusses what they say.
Anonymous, is that the page number stamped on the page, or is that the PDF page number?
It's only the PDF numbers because those other numbers are kind of wonky right now. But yeah, okay. It's only PDF. I apologize.
Give that number again, please. That page number.
147.
Certain.
147.
No, I thought he said 140 or 147.
147.
Hold on. Let me flip back to the page, and I believe the clerk is right. It is 147, which is footer 128. And the other example, which just has a lot more information, so you can say, hey, how could you redact it, is the one on page, it's a commercial, yes, it's page 136, because we discussed this at the full task force. Right, this is a commercial agreement. This is PDF page 136. And this is a commercial agreement, or potential for a commercial agreement between the SFPD and Allied Universal Event Services. And the notion that they are going to have this discussion and an email came in and was made part of this meeting from a private person trying to get the SFPD to do some sort of lunch with them and sell something to you, there is nothing secret about that information. It's in fact why I care about this, right? That's the kind of information that you could hide outside of San Francisco because deliberative process, but you can't hide it in San Francisco. The fact that he was trying to make one of these decisions and discussions with, some guy trying to sell the city services. You could have hidden, as they did hide, where it would be or what time, maybe, but not the rest of the content. And I just want to remind you, you're here, I believe, not to overturn or agree with your prior decision. I believe the way this meeting is only to determine whether they are to send it back to see whether they are willfully or not complying. If I remember correctly, I haven't done one of these before.
Yes.
So
that's what we will be discussing. Thank you. So members, how would we? I think we have information from both sides in this review of the case. How would we like to proceed? I mean, it seems like we are hearing from the respondent that they know what our order was and are choosing to not follow it. Do we need to send this back to the full task force?
Well, I think I'm not. I don't feel convinced of the new defense that the respondent brings forward. It's been somewhat difficult for this task force over the past 20 years that when respondents come in and we expect a citation, that there's a full explanation into the context and the details of how that particular piece of information that's being withheld, how the law actually applies to it explicitly. Now, there could be some implication, it could be implicit, but at least there has to be some presentation of that. And I'm not hearing that. And the question is I don't know if it's in the way it's being presented, or that maybe it's not being presented correctly. But I'm not convinced. And I just hear now a retraction, an about face, and a digging into the heels that is not necessarily based upon a decision of the police department, but a decision of their legal counsel. As part of, and that's how I heard it, that legal counsel is the one that's telling them to do this, and that they need to do that, and they agree with legal counsel to do that. It's actually it's supposed to work the other way around. You take advice from legal counsel, you make your own decision, and I'm a little concerned about that, because it's just wrong. I just feel it's wrong because this is not, again, it's not novel to us. There are countless orders of determination by this task force around the calendars, and that's why Prop G, the calendars were specifically laid out in context in Prop G, just to deal exactly with this particular kind of issue, so that there was some clarity, versus other types of documents. And I guess at the time this was a hot topic that it made it into the statute. So, I'm concerned about this because I'm concerned about this, like with other trends that various officials have tried to use to skirt the release of public information that the public pays these people for, and the public has a general right to know. And so in the interest of the public, I think should be some further adjudication of this reversal.
Member Highland, do you have anything to add?
Not to that, no.
Okay. So, do we have a motion on this then?
Well, I would move to definitely report this to the task force, that with the information that the committee is not satisfied with the compliance or the lack of, and the willful reversal of the task force's order. And let the task force determine what the dispensation is. But that's our find. That to me, that's what I'm hearing is the finding here. That's what I'm finding.
I'll second that.
Is there any public comment on this motion from parties not involved with the case?
Yes. Hello, can you hear me?
Yes. One moment. We'll wait for the signal on the timer.
Go ahead, sir.
Yes, hi, this is Hank Heckel. I'm the compliance officer in the Office of the Mayor. Good evening, members of the task force. Good to be with you virtually again. I was listening in on the meeting and this matter, and I was interested in Anonymous's comments. He was citing to statements that he alleges I made at a previous hearing on kind of a related issue regarding the mayor's future calendar entries. And I just want to correct the record on that. I think it was a little bit taken out of context. I think what happened was there was a discussion at that hearing back in November of whether the mayor's future calendar should be disclosed. And we had similarly relied on the 62.4F security procedures exemption in connection with the Times Mirror case, and arguing that the details of the mayor's security, the safeguarding her, and preventing release of whereabouts and times and locations of meeting was paramount. And so I think I was asked a question at that hearing as to whether other particulars of future calendar entries, just like the subject of a meeting, could be disclosed. And I don't think that wasn't raised initially in Anonymous's complaint, so it wasn't something we really considered, and I said we would look at it. So I don't think we were agreeing to the proposition that you could just redact out, any of the particulars that are sort of most sensitive. I think you have to look at it holistically. And, the issue is if someone
request a calendar in like a week period, I mean, everyone knows what a calendar looks like, right? So you could redact the day, but everyone knows it's Wednesday of that week, and they know particular meetings with particular parties to be taking place. And so, interested people intending to disrupt those meetings, et cetera, could be given information that could then jeopardize and complicate and make difficult the PD's ability to provide security to the mayor, because the PD provides security to the mayor for all of her meetings. And similarly for Chief Scott, obviously the police provide security detail for his meetings as well. And so we agree with the PD's position as asserted presently. And I just wanted to correct the record as to what our position was and what my comments were. And if I could just note also, there was a reference to Prop G. I mean, we totally agree that Prop G is a critical tool of transparency and is very important. It's something we take very seriously, but it's backwards looking, right? I mean, we produce the meetings that have happened in the past, including the very recent past, because you update the Prop G on every 3 days you update it, right? So we may not tell you the details of the meetings upcoming next Tuesday, but if you ask for them the following Friday, you would get that information. And we think the Times Mirror case supports this because there's a discussion of the governor's calendar, his travel habits, his sort of scheduling practices and patterns that, if were revealed, would jeopardize the governor's security. We think that's applicable here as well. Thank you.
Thank you. Member Highland, I see you would like to make a comment.
Yeah, I need to step away for about 5 minutes. Are you going to take a vote on this, or is there more public comment?
Is there any additional public comment? Seeing none, let's please call roll.
Okay. Member Wolf?
Aye.
Member Wolf, aye. Member Highland?
Aye.
Member Highland, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Motion passes.
Thank you, everyone.
That is the last file for tonight.
Okay. If you could please call the next item then.
Item number 8, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
So, Member Wolf, do we have anything else to discuss?
No.
I think we have a lot ahead of us, but I don't think there are any additional items to discuss at this time.
No, I would just as we begin to continue to have more and more of these now, our regular meetings, that we just take some stock into how we can tweak them and massage them and make them as close to being the in-person type of meeting as possible, and share that with the rest of the task force or other committees too, if anybody has any thoughts. Yeah. And I would like to adjourn in memory of RBG.
Yes.
Yes.
Absolutely.
I think we should do that. Please call the final item.
Public comment.
Oh, public comment. Excuse me, public comment. Seeing no public comment, please call the final item.
Item number 9, adjournment. I have 6:51 p.m.
I move to adjourn.
By acclamation. Or I guess I second, since I'm the only one here.
Sure. Let's just say
all right,
all those
6:52.
in favor.
All those in favor.
Aye.
Aye.
Thank you.
Thank you, everyone. See you
Thanks.
in October.
Yeah.
Bye-bye.
Take care.
Yeah, boy, I took a lot of notes for this hearing. Does anybody have anything they need to tell me for in preparation for the task force hearing? Is there anything I should keep in mind?
Can you stop the recording?
Yes, let me just talk through that.